I'm Lisa Sornin, Executive Director of the State and Local Legal Center. A few housekeeping matters before we begin. During the presentation, you will be able to ask questions through the box on the left-hand side of your screen on the bottom. Simply type in your question and click Ask. A recording of this webinar will be available on the State and Local Legal Center's website following this webinar. For those of you who are new to the State and Local Legal Center, the SLLC files amicus briefs before the Supreme Court on behalf of its members, comprised of the Big Seven national organizations representing the interests of state and local government. These groups and the SLLC's two associate members, the International Municipal Lawyers Association and the Government Finance Officers Association, are listed on this screen. Since 1983, the SLLC has filed over 300 Supreme Court amicus briefs. This term, we will file 12. The SLLC is also a resource to the Big Seven on the Supreme Court, and this webinar is an example. I will now introduce our speaker. Hashim Mooppan is a partner with Jones Day in Washington, D.C. He argued this case before the Supreme Court on behalf of the Dental Board. Welcome.
Thanks, Lisa. Thanks for having me. And let me just clarify quickly that my views today are my own. I'm not speaking on behalf of either the Dental Board or my law firm.
Thank you. So we'll start with my first question, which is an overview of the case. In North Carolina Board of Dental Examiners versus FTC, the Supreme Court held 6-3 that when a controlling number of state board members are market participants, the board must be actively supervised to be exempt from federal antitrust liability. Or law, rather. Walk us through the pre-Supreme Court history of the case. Describe the background, the relevant legal issues, and how the lower court ruled.
So under the state action doctrine, which was first recognized in Parker versus Brown, federal antitrust law does not apply to acts of sovereign state regulation in light of the federalism concerns that would be presented by interpreting federal law to intrude on state sovereignty. Prior to this case, the court had essentially identified three categories of actors. There was the sovereign state itself, i.e. the state legislature or the state Supreme Court, and the acts of those entities were automatically immune. The next category were municipalities and likely state agencies, where the court had held that those entities were immune so long as they were implementing a clearly articulated sovereign policy to displace competition. And then the final category that the court had identified were private actors, and they were immune so long as they both met the clearly articulated requirement that applies to municipalities and state agencies, and also were actively supervised by state officials. And so then the question that was presented in this case is, what do you do with what's a so-called hybrid state agency, one that's run by part-time public officials, but there are also private market participants in their personal capacity. So the facts of this case were that a majority of the North Carolina State Dental Board consists of actively practicing dentists who have been elected by the state's other dentists. The dental board here sent cease and desist letters to non-dentists who were performing teeth whitening, saying that that was the practice of dentistry, and so they therefore had to stop. The FTC challenged those letters under the antitrust laws, and the FTC held that the board didn't get state action immunity. It reasoned that the board should be treated like a private party because of its composition, and it held that the board wasn't actively supervised, as private parties must be. The Fourth Circuit affirmed that holding, and then the Supreme Court granted our cert petition.
Well, as I mentioned, you represented the dental board before the Supreme Court. What arguments did you make in your brief in favor of the dental board, and what arguments did the FTC make?
So, the board argued that in light of the federalism concerns that animate state action doctrine, it should be irrelevant that a state agency is staffed by part-time public officials who are also private market participants. That's a sovereign decision for the state to make, we argued, and the state is free to decide whether the benefits of professional expertise outweigh the costs of potential conflicts of interest. And indeed, that's exactly the choice that all the states have made for the major professions, and they've done so for decades. Virtually every state, medical board, dental board, state bar, consists of a majority of practicing professionals who are not necessarily actively supervised by other state officials. Moreover, we argued that the court had held in a case called Omni that immunity applies even to public officials who are being bribed by private parties. And if that's the case, there's no reason why a mere potential conflict of interest should cause the loss of immunity. So we essentially argue that active supervision is only necessary for private parties who are acting in their capacities as private parties, because such parties are presumptively subject to federal law, and the state can't just immunize them from federal law unless the state makes their acts its own through active supervision. But we argue that such supervision is entirely unnecessary where private parties are acting in their capacities as public agency officials, since the state has already made their acts its own by creating the agency. Simply put, we argue that the key distinction for active supervision is between private actors and public officials, regardless of the motives or incentives of the public officials. By contrast, the FTC argued that active supervision is necessary whenever there's a serious risk that the defendant is acting to further private interests rather than the state's interest. The FTC based that argument on the rationale of a case called Halley, the case that held that municipalities don't need to be actively supervised. And in particular, the FTC emphasized that in the course of that discussion, the court had observed that there was no real danger that municipalities act to further private interests. So the FTC argued when that is the case, when there is a danger that a state entity is acting to further private interests, it should be actively supervised. And the FTC argued that that's the case for so-called hybrid agencies, given their potential conflicts of interest. So in short, the FTC's argument was that the key distinction for active supervision is between disinterested actors and self-interested actors, regardless of their public or private status.
So what was the court's reasoning concluding that state action immunity only exists if boards and commissions controlled by market participants are actively supervised? Why did the dissenting justices disagree?
So the two sides of the court basically adopted our respective positions. The majority essentially adopted the FTC's view in whole. They held that the active supervision requirement presumptively applies to all non-sovereign actors, whether public or private, because the clear articulation requirement isn't sufficient by itself. And they said that the reason that's true is because even when there's a clearly articulated policy to displace competition, there's still going to be interstitial decisions that have to be made about how to implement that policy. And if there's a risk that the relevant defendant is acting in its own interest rather than the state's interest, you need active supervision to prevent that. And so based on that logic, they held that the only time active supervision isn't required is where there's no real risk that the actor is seeking to further private interest rather than the state's own interest. And the court held that that wasn't the case in Halley, but they held that it is the case for a board like this one, where a controlling number of the decision makers are active market participants in the occupation the board regulates. The court tried to minimize the burden of its holding by suggesting that board members might still have immunity from damages or could be indemnified by the state, and the court also suggested that active supervision might not be so hard to provide, but it didn't really get into the details, as we'll discuss in a little bit. As for the dissent, they essentially adopted the board's view. They argued that in light of federalism, the key distinction should be between private actors and public officials, regardless of motives or incentives. The dissent emphasized that such boards are pervasive and long-standing, and there's no reason to think that federal antitrust law was intended to interfere with the state's sovereign decision that such boards should be used. The dissent also emphasized that the majority's unprecedented position raised a host of practical problems and questions about the scope of its ruling, and I think that's what we're going to discuss next.
Yes, exactly. Until the FTC or the lower courts provide answers, how would you answer Justice Alito's questions from the dissent about the unanswered things in these cases? His first question was, what's a controlling number of market participants?
So it's pretty clear that a majority is definitely sufficient, because that was the facts of our case, and the court held that we satisfied the test. But it's probably not the case that a majority is necessary. The court used the term controlling rather than majority, presumably for a reason, and the word controlling was actually part of the FTC's test in its decision below. And it seems pretty clear that what the FTC has in mind is that even if there isn't a majority of active market participants, if there's a large plurality that has effective control, that should count. Now, how you assess what counts as a sufficiently large enough plurality to be controlling is an open question that will presumably have to be litigated over time, to the extent that states decide to retain a significant, though non-majority, of market participants on board.
So the second question is, who is an active market participant?
And that's going to be a lot tougher call, I think, to know how courts and the FTC are going to resolve that question. Obviously, if you take people who have no connection to the market involved, they're going to be protected. But I assume a lot of states are going to be disinclined to have people who have no knowledge or expertise in the relevant profession regulating the profession. So the real questions, I think, are going to be things like, well, can states use retired professionals? Can they use professionals who suspend their practice for a few years to serve on the board? Those people aren't active market participants. They're people who previously used to participate in the market and might well participate in the market again in the future. I think if you ask the question literally, are they active market participants? The answer is probably no. But the real question is going to be, well, are the FTC and the courts going to extend this decision to such boards? Because those people, even though they're not active market participants, might have a sufficiently high interest in what they're doing that courts feel that the active supervision is required. It seems to me that that's probably a greater likelihood with respect to boards that have professionals who are only suspending their practice, as opposed to retired professionals who will never practice again, or or something like academics. If you pull in people from medical schools or dental schools or law schools to serve on these boards. So states, I think, have a fair amount of flexibility in trying to structure the board, but it's not necessarily clear who's going to be deemed an active market participant or equivalent to one for purposes of this rule.
All right, so you don't have to answer all the next questions, but then Justice Alito went into sort of a string of questions that he had, and they are as follows. What is the scope of the market in which a member may not participate while serving on a board? Must the market be relevant to the particular regulation being challenged or merely to the jurisdiction of the entire agency? Would the result in the present case be different if a majority of the board members, though practicing dentists, did not provide teeth whitening services? What if they were orthodontists, periodontists, and the like? How much participation makes a person active in the market?
Well, so the court defined its rule actually as whether there are market participants in the occupation being regulated. So it's pretty clear, I think, that it's irrelevant whether a majority of the dentists actually perform the particular service at issue, for example, here teeth whitening, or in any other future case. No one's under the holding of this case. It's not going to matter whether a majority of the individuals on the board perform the particular service at issue, as long as they're all in the same occupation. But of course, that just raises the question of what is the relevant, quote, occupation. Are dentists and orthodontists and periodontists different occupations, or are they sufficiently similar occupations? Just like the questions about what's controlling and what is, who is an active market participant, I think there's going to be open questions and potential litigation, because I assume the FTC will argue that sufficiently closely related occupations present the same risk as all people in the same exact occupation.
Okay, so states have three options for complying with this ruling. First, they can choose not to put a controlling number of market participants on boards. Second, they can actively supervise boards where market participants make up a controlling number of members. Third, they can forego state action immunity by not actively supervising boards and keeping a controlling number of market participants on boards. Talk about each of those options.
Sure. So the first option would be to change the composition of the board to set it up in a way that it's just categorically outside of this rule and therefore still can still invoke immunity. But there are both practical and legal difficulties with going this route, though there are also practical and legal difficulties with going either of the other two routes as well. So the first issue, as I mentioned before, is states presumably want and need experts on these boards. You probably don't want people regulating professions who have no idea what's going on in the profession. So there's going to be at least some need to have people with some amount of familiarity with the subject at issue. And the problem, of course, is going to be the more expertise you have, the more likely the FTC and courts are going to start arguing that the board is likely to be acting in the interests of the regulated profession rather than in the interests of the state. So it's going to require sort of a difficult balance of picking people who have enough expertise to satisfy the state's interest, but are sufficiently financially disinterested that the FTC and the courts will be comfortable saying active supervision isn't required. And then the final caveat on this element is often many boards, their composition is dictated by statute. So if a state wants to change the composition of its board, that's going to require legislative action, which of course can be difficult. But this difficulty actually is also going to be presented for both of the other options. So, and let me just explain that as I go through these next two options. The second option is that the states could try to actively supervise boards that have active market participants controlling them. Again, though, this presents practical and legal difficulties. To begin, if it's not clear that non-professionals who are just full-time government bureaucrats will have the ability, as a practical matter, to supervise the substantive decisions of professionals. It's not clear that, for example, a general bureaucrat in a state's like health department is competent to make determinations on whether a state medical board properly granted or denied a medical license to an individual applicant. Even if government bureaucrats who were not professionals could perform that sort of active supervision, it's also not clear how much review is actually required to satisfy the active supervision requirement. The court didn't say very much about this issue in its opinion. The little it said is that the supervisor must actually review the substantive merits of the decision, not just the procedural correctness, and that the supervisor has to have the power to reverse particular decisions. But what it doesn't tell you is what happens if, in case after case, the supervisor reviews the decision and approves it, and then someone comes in and says, look, the supervisor isn't really reviewing it, it's really just rubber stamping it. Are those sort of supervisory decisions going to be open to be second-guessed in federal courts and before the FTC? If so, is that really going to provide sufficient clarity to the boards ex ante that people are willing to serve on the boards? So those are pretty difficult questions, and I think they're largely going to be unresolved until you have further litigation sort of fleshing out what the FTC and the courts mean by active supervision in this context. The one good note on this is that the court did emphasize that active supervision is flexible and context dependent. And I think what they're suggesting is that the level of active supervision that you might require for a purely private party might not be required for a state agency just because its officials are market participants. Justice Breyer, during oral argument, sort of hinted at this a couple of times, as did Justice Kagan. I think that everyone sort of recognizes that the full-blown, sort of very rigorous standards you need to take a private business decision and make it the state's own through supervision would be an inappropriate burden to impose on one state agency reviewing another state agency. So there's some reason to be cautiously optimistic that as long as there is substantive review and the agency does have the ability to countermand the board's decisions, that there might be active supervision found there, even if there isn't a lot of times where reversal actually occurs. But like I said, that it's going to need liquidation through further litigation. And the final difficulty with this option is here, too, you might need legislative action to create the supervisory mechanisms, because I assume a lot of these boards aren't, under current state statutes, subject to supervision, and it's not clear that some other state agency can just assert jurisdiction over them without change to the state statutes. So the final option that states have would be to not change anything, leave the composition the way it is, not necessarily supervise the board, and then just run the risk of antitrust liability. Now, that's obviously a fairly risky proposition, and it would also pretty likely deter professionals from serving on these boards. But there are ways that states could minimize those risks. First and foremost, they would almost certainly have to indemnify officials who served on the board. But even that could be pretty expensive given that antitrust often could involve trivial damages. I think what really is going to determine whether this is a practically feasible thing for states to do is whether the sort of activities that these boards typically engage in present a high likelihood of antitrust liability. And that, I think, is going to turn on the following question. When state licensing agencies, are state licensing agencies without immunity subject to antitrust liability when they deny individual licenses based on some sort of group boycott theory, right? Because what the bread and butter of what most of these professional boards do is grant licenses. And so if that is not the sort of thing that is a substantive matter of antitrust law, isn't going to give rise to liability, then it might be the case that boards can weather this decision because there's not a serious enough risk of antitrust liability if they just stick to licensing and they don't do things that are at a higher level, more general level of application, like what the dental board did here about trying to stop non-dentists from practicing teeth whitening. But it's not at all clear whether the individual licensing decisions would be subject to antitrust liability. You could easily imagine that the FTC or a private plaintiff could argue that these 7 members on a state agency, state licensing board, are basically collectively agreeing to boycott their competitors by denying individual competitors licenses. And I think there are arguments that can be made for or against that under a substantive antitrust law. But I think that's probably the most important question on this third option. Again, though, even this third option, it seems pretty clear that it's going to require at least some legislative activity because I assume you would need state statutes to extend indemnification if it doesn't already exist. And so my instinct is, given that all 3 of these options sort of present difficulties, and since all 3 of them also likely require legislative action, perhaps the safest thing for states to do is to do a little bit of all 3 through legislation. You know, they would partially change the composition to decrease the amount of financial disinterest on the board, but still preserve some amount of expertise, create some amount of supervision so that even if that first step doesn't do the trick, maybe the board will be found to be actively supervised, but to do it in a way that is actually practically feasible. And third, potentially limit the amount of things that these boards can do so that maybe their substantive sphere of activity is less likely to trigger antitrust liability, even if they don't have immunity. That sort of, a menu of options, I think, is how states should go about it, probably then picking one and putting all their eggs in that basket.
So do you think the court's ruling in Halley versus Eau Claire that municipalities don't have to be actively supervised, and its ruling in Columbia versus Omni Outdoor Advertising that state action immunity isn't conditioned on a proper use of state regulatory authority are in trouble?
No, I don't think those holdings are in trouble. Both of them were expressly reaffirmed in the opinion, though the court distinguished them. The court said that municipalities don't need to be actively supervised because they don't present the risk of self-interest that these boards do. Likewise, the court held that Omni's holding that it doesn't matter whether the state actor is properly using regulatory authority. That's the law, but the court just said that's all the more reason why we should only have immunity for agencies that we can trust to properly exercise their authority as an ex ante matter. Omni said we're not going to, at least as the court explained Omni says we're not going to second guess their decisions on the back end, but what the court held in this case is that we will look at how they're structured on the front end and decide whether they're the sort of board that we're willing to trust. So there is one thing that might be in trouble based on the court's decision. It's not actually a Supreme Court holding, it's really the state of the law in the lower court. So in Halley, when the court said that municipalities are exempt, what the court also said is that state agencies, it has a footnote that said state agencies are, quote, likely exempt. And the lower courts had uniformly held that truly public agencies, i.e. agencies that didn't have any officials who were also private market participants, were exempt from the active supervision requirement. But after this decision, it's pretty clear that the relevant line isn't between public and private anymore. It's between disinterested and potentially self-interested. And so I think plaintiffs and the FTC could, if they want, try to argue that even boards that don't have any market participants on them need to be actively supervised because there's too high a danger that they're still furthering private interests rather than the states. Not because of the way they're composed, but rather because of the risk of regulatory capture, i.e., the well-known phenomena that special interests have oversized influence on their decision. I doubt the FTC is going to push that argument anytime soon because it's a lot more aggressive and would be a lot more disruptive, but it's not inconceivable that private parties could, especially if they sort of focus their efforts on particular boards that seem particularly vulnerable to regulatory capture. So that strikes me as the one area where this opinion, other than its direct holding, could have sort of a more broader destabilizing effect on the current state of the law in a way that's adverse to the states.
For over a decade, the FTC has made it clear that it is interested in weakening the state action doctrine. Do you think this case was part of their strategy? And what is the significance of the FTC winning this case and winning FTC versus Phoebe Putney Health System?
So I do think this case was clearly part of the FTC strategy. In the early 2000s, the FTC had a state action task force report that laid out a whole host of the FTC's objections to the scope of the state action doctrine and explained the sort of things that they wanted the courts to narrow. This issue about what type of agencies are subject to active supervision was one of those, one of the things that the report identified. The court's decision in Phoebe Putney, the issue in the court's decision in Phoebe Putney, namely what the scope was of the clear articulation requirement, was another one. So it's pretty clear that the FTC had an agenda and has pretty successfully pursued the agenda now. And I think the significance is that it's pretty clear that at least a current majority of the court shares the FTC's deep skepticism of the state action immunity, which the court has now repeatedly described as disfavored.
So on that note, what might be the next state action immunity issue that the FTC will try to get before the Supreme Court?
So I think there are one, if not two. I think if you look at the State Action Task Force report, that'll give you a good sense of where they might go next. The thing that I think they're most likely to go after next is the issue of whether there's a so-called market participant exception to state action immunity. And that's the issue of whether when a state or municipal government is acting not necessarily in its regulatory capacity, but instead as a profit-making enterprise, whether its actions in that context and state laws and municipal laws that sort of benefited while acting in that profit-making context are subject to the state action immunity. The FTC is definitely going to push pretty hard for the notion that the immunity should be limited to, quote-unquote, regulatory action, not private, profit-making activity. So I think that's the one they're most likely to pursue, both because it sort of follows naturally from this decision and because they've got pretty decent arguments that the federalism interests implicated are attenuated when you're dealing with profit-making activities by state and local governments rather than regulatory activity. Of course, drawing the line between regulatory activity and market participation, it will be a difficult one, but it's a line that arises in a lot of other areas of the law, such as, the Dormant Commerce Clause. And so I think that the FTC is likely to go in that route. One other issue that the FTC and academic commentators are always emphasizing is the issue of interstate spillovers, which is the issue that when a state acts anti-competitively and has immunity, the harms from that anti-competitive regulation might not just fall within the state, but it might fall on consumers outside the state. And the FTC and a lot of academic commentators really wish it were the case that there wouldn't be immunity in that circumstance, that immunity would be narrowed somehow in that circumstance. But the problem for them on that front is that the leading Supreme Court case that recognized state action immunity, Parker versus Brown, is the quintessential example of an interstate spillover. Because there it was California regulating the price of raisins, even though the vast, vast majority of raisins produced in California were then sold out of state. And so it's pretty difficult for any lower court, and frankly even the Supreme Court, to say interstate spillovers are relevant to the to the state action immunity doctrine given Parker. It seems pretty clear that the more proper way to analyze those sort of issues is through the Dormant Commerce Clause. So I doubt that the FTC is going to go after this issue, but they might, and maybe private parties might. But I think market participant is probably the more likely thing. And I guess one last thing, which isn't really an issue per se, but as I said before, I think there's likely to be a fair amount of litigation over what counts as active supervision, and that might get up to the court relatively quickly, depending on how these cases get litigated and resolved.
Well, at this time, let's take some questions from the audience. So audience members, if you would like to ask a question, there is a box on your screen on the bottom left-hand side. Simply type your question in and hit ask, and I will read the questions.
Don't be bashful.
We don't have any questions yet, but I'm thinking some will come in.
I'm very sorry. This is Tricia, and we actually do have some questions in, and I apologize. If you will, Lisa.
Yes.
Click on the Q&A, the down box.
Yes.
Click on moderator, click on.
Oh my goodness.
Hey, there you go.
We have a sea of questions. All right. Let's start at the top. If a state medical board dominated by active market participants and unsupervised by another arm of the state refuses to grant medical license to applicants who have not graduated from approved medical school, do those board members violate antitrust laws?
Yeah, so I think there are two aspects to that question. If a state statute makes the graduation requirement a legal requirement for getting a license, then there's not going to be any issue because that statutory requirement is the act of the state per se, because it's the act of the legislature. But if that's not set forth in the state statute, if it's a discretionary decision that the state medical board has made, maybe a perfectly permissible one interpreting the state statutes and pursuant to delegated authority, that if the board doesn't have state action immunity, is at least potentially subject to antitrust liability. Now, whether it would be an antitrust violation is the question is the issue I identified earlier. It would be the question of whether adopting that sort of requirement is vulnerable to challenge as sort of a per se group boycott, and if it's not, is it subject to rule of reason analysis? I can't really give you a definitive answer on that because it's, to my mind, a difficult and open question of substantive antitrust law, and I'm not substantive antitrust lawyer. But that is definitely that's the way you need to go about analyzing the question is it required by state statute? And if it's not required by state statute, what's the proper substantive antitrust way of thinking about it?
Okay, so the next question is one that I've given a lot of thought to, too. So the Fourth Circuit was explicit, at least in the concurring opinion, that the most salient point was that the licensed dentist elected board members as opposed to being appointed by the governor. Why do you think the Supreme Court ignored or at least downplayed that distinction?
So I think they did because everyone, virtually all the parties on both sides argued that the distinction didn't matter. You know, for our part, we of course argued it didn't matter because the method of election is also a state sovereign decision that the federal antitrust law should perhaps more importantly for present purposes, the FTC argued it shouldn't matter because the method of election at most makes the risk of self-interest marginally greater. And what I think the FTC was worried about is that boards that with the elected structure like North Carolina are far, far less common than boards that aren't elected. So they didn't want their rule to be pretty practically meaningless. They, I think, were also concerned, and this was played up pretty heavily by the FTC's amici, and we actually made the same argument coming from the other direction, that even when the members of the boards aren't elected per se by market participants, even when the governor is the one who's appointing them, that's almost invariably pursuant to either formal or informal input from state professional associations. So lots of states, either by statute or by practice, require the governor to either consider or even sometimes the governor must pick from sort of a list provided by the state professional association. And it's pretty hard to draw a meaningful line between that and direct election with respect to the concerns that were motivating the court and the FTC. So it just didn't seem to anyone like the method of election was a really principled place to draw the line. The only benefit it really had was it would have made the opinion narrow. But it seems like neither the court just wasn't concerned about going broader.
All right, next question. In North Carolina, the board issued a cease and desist letter on its own as a policy matter. Would the court have viewed it differently if the violation came via an unlicensed prosecution initiated by prosecutors separate and apart from the board members?
Yeah, I think they would have, right? If it had been the actions of the state attorney general, the state district attorney or whoever in North Carolina, I guess it's the district attorneys in North Carolina who have the authority to prosecute for unlicensed practice of dentistry, then those individuals aren't active market participants. They would just be quintessential public officials who, under Halley, would almost certainly be immune so long as they're acting pursuant to a clearly articulated policy. And in that context, both the fact that there was state statute involved and the fact that the mere act of initiating a prosecution doesn't really have an anti-competitive effect. So there would only be an anti-competitive effect if they won in state court. And at that point, you would both have the state court's blessing and confirmation that the statute actually meant this. It would be almost certainly the case that there would be immunity.
Okay, what is the likelihood that opportunity for state judicial review under the State's Administrative Procedures Act would be sufficient to constitute active supervision?
It's a good question. So I don't think the mere opportunity would be enough because the court was quite explicit and consistent with a case called Tycor that the mere potential for review isn't enough. There actually has to be actual review. So I think you would need to have a couple of things happen in all likelihood. First, in all likelihood, the rule probably can't go into effect or the decision can't go into effect until it's been reviewed under the APA. And under the APA review, it probably would have to be the case that the court has the ability to substantively reverse the particular decision. The tricky issue is going to be what level of deference applies. So in states where under their state's APA, agency decisions are entitled to significant amounts of deference, akin to Chevron deference in the federal system, that's going to raise a question about whether that's sufficiently independent supervision to satisfy active supervision. But certainly, if there's de novo review on the legal merits, and the court exercises that de novo legal review before the rule goes into effect, then that would almost certainly be active supervision.
All right, next question. In regard to the comment about risk of antitrust and denying licensure as some sort of group boycott, isn't this risk mitigated by objective standards that all applicants for licensure will be subject to, assuming the standards conform to industry standards of care/knowledge? Or could there still not be enough separation there?
Let me just read that again. You don't have to read it out loud, but. So I'm not sure that, so again, I'm not a substantive antitrust lawyer, so this is a little bit far afield from my expertise based on this case, but I wouldn't think the fact that the standards were clear would necessarily have an impact on whether the standards violated antitrust law, because you could have a clear anti-competitive restraint. I think the question would be sort of along the lines of the initial question, whether it's somehow improperly restraining trade for 7 people to disagree that individual people don't meet required standards, which doesn't, in and of itself, each individual license denial doesn't have much of an effect on the market, but maybe in the aggregate they do, and the question is, how do you analyze that? Does it matter that there's not any effect on the market from an individual? And part of that's going to turn on whether you view this as sort of a per se antitrust violation or not. But again, that's a little bit far afield of my area of expertise.
Why was it stipulated that there was clear articulation in the North Carolina Dental Board case? There was no statute stating that whitening was a practice of dentistry?
So I think there are 2 reasons for that, one strategic and one legal. The legal reason, I think, is that even though there wasn't a statute that expressly said that teeth whitening was the practice of dentistry, there was a statute that expressly said that the removal of stains was the practice of dentistry. And whether or not the state was correct, the board was correct in interpreting that provision to apply, seems like a substantive decision that doesn't really implicate the clearly articulated prong of Mid-Cal. And we know that from cases like Omni, where the court explained that clear articulation is satisfied so long as the statute clearly displaces competition, regardless of whether the individual decision was in compliance with the statute. So in cases like Omni, that you have a statute that authorizes the state to zone billboards. That on its face is obviously anti-competitive because it's carving up a market. Now, the statute had all sorts of substantive and procedural requirements you had to jump through to actually issue a zoning ordinance. And it wasn't at all clear that the South Carolina city in Omni had satisfied each and every jot and tittle of that statute. But the court said that doesn't matter. That's a question for state administrative review. As far as state action immunity is concerned, it's sufficient that the statute clearly dismisses competition and that the city is at least colorably invoking it. So the court sort of held open the possibility that if you're acting clearly ultra vires, maybe you would lose the immunity. But as long as it's at least debatable, the court was saying that that's good enough. And notably, the court in the dental board case actually cited that portion of Omni favorably, or at least didn't suggest that it was no longer the law. So that's the legal reason. The strategic reason, I think, is because the FTC wanted to push this active supervision issue in this case. They viewed this case as a good test case for the active supervision issue, and so they ducked the clear articulation requirement so it would be clearly presented, I think, but I don't know that for sure.
So the next 2 questions you can decide, or you can answer together. What do you think will happen next? Will the FTC try to take action against all state licensing boards? And then the other sort of related question is, when should we begin making changes or wait? Or should we begin making changes or wait?
So I don't think that they're going to sort of launch a wholesale assault against all state action, all state licensing boards. I think that would sort of give the lie to the notion that this is a more modest decision. I think they'll pick and choose their targets. I think they're more likely to go after the, less familiar licensing boards, the things that people think are more likely to be pretexts for protectionism. Without intending any pejorativeness to the particular one I'm about to pick, stuff like, the florist regulatory board, right, as opposed to the dental board. People are a lot more skeptical that you actually need a licensing board for florists. So I think they might go after those sort of boards or other boards where the substantive decisions being made seem dubious. I doubt they'll go after everyone. As for whether states should start acting proactively, my instinct is I probably would, but I understand that there are all sorts of political impediments to changing state laws. But given I would think that having antitrust liability hanging over your head is not something that would be conducive to good state regulation and getting people, competent professionals, to serve on the board. So I would presumably think that states would be well advised to start sooner rather than later.
Okay, next question. You didn't spend much time on the first prong of the Mitica test. Can you explain why?
The first prong is whether there's a clearly articulated state policy to displace competition. The reason I didn't spend much time on it is, as I was saying in the earlier question, the FTC had assumed that prong was satisfied below, and I think it pretty clearly was satisfied below because of the fact that the statute authorizes, the statute expressly says that you can't practice dentistry unless you're a licensed dentist, and expressly says that removal of stains is the practice of dentistry, and the question of whether teeth whitening falls within that prohibition is a question of state law. It's not a question of federal law for purposes of the first prong.
Okay. How do you think the record regarding the public safety interest affected the outcome?
I don't think it had much of an effect. I'm not 100% sure. We in our Supreme Court merits brief didn't try to fight it at all, both because it wasn't legally relevant and because it's pretty hard to fight factual findings from the FTC in the Supreme Court brief. But I really don't think it would have had much of an effect because the court seemed to be concerned about a structural bias rather than any particular individual decision. The court actually went out of its way a couple of times to say that they weren't suggesting that the board had been acting in good faith, or was not acting in good faith, that they weren't suggesting that individual decisions were going to be made for profit reasons rather than public safety reasons. What they were emphasizing was often in their perceptions, subjectively and subconsciously, people who have an interest are going to find it difficult to divorce those private interests from the public interest. And given that sort of vague potential conflict of interest view of the issue problem, I don't think the court would have been swayed much if there was much stronger evidence that what the board was doing here was in the public interest in terms of health and safety.
Okay, next question. To what extent do you think a safe harbor of board composition will develop? For example, if we reduce the percent of non-market participants to 10 to 20%, for example, might the courts do a case-by-case analysis to determine what extent the non-practicing members defer to the practicing members?
Yeah, look, so I think that's the question about what it means to be controlling. I assume that if you were, I guess I shouldn't say I assume anything. I would think at a certain level of a sufficiently small percentage, you would think that it's not controlling, even if the non-participating members routinely defer. But I don't know. It's very hard to say how it's going to play out in practice. I sort of suspect that courts and the FTC are going to want to be reasonable about this, but you never know. I would think it's much more likely to be a problem if you're just shy of a majority, if you're at like 40% or 30%. and the people in between 40 and 50, especially if they're sort of not active market participants but closely related fields or retired or something like that. But if you've got 70% totally disinterested people and 30% experts, the mere fact that they're deferring doesn't show it's controlling. It shows that you put experts on these for a reason. So I would think the states would have pretty good arguments, but I don't think anything can really be clear or safe harbor at this point. And I guess that does sort of tie into a more general point, which is one particular thing the states might want to do is if the FTC is willing to sort of issue any sort of guidance or safe harbors along these lines about what sort of composition will be deemed non-controlling, et cetera, that will at least protect you from the FTC. I'm not sure whether it would necessarily be given deference in a court case brought by a private plaintiff, but it would certainly go a long way to giving you the sort of protection you want.
Can active supervision be limited to certain categories of cases, scope of practice, cease and desist orders against unlicensed persons? Will this be unacceptable, or do all decisions require the structure of active supervision?
Yeah, I don't think it's going to be feasible to say that if the board is structured in such a way that it has too many active market participants, such that it otherwise generally needs to be actively supervised, I don't think you're going to be able to carve off certain issues and say those issues somehow don't need to be actively supervised, because it'd be pretty hard to see why certain issues present less of a risk than other issues. The substantive nature of the issue is going to have much more of an effect on whether it's a substantive antitrust violation than whether it's the sort of issue that needs to be actively supervised. So while I'm not 100% sure, I'm skeptical that sort of line can be drawn at the active supervision stage rather than at the merit stage.
Why was little mention made of the board's actions being ultra-virus?
It goes back to the issue we were talking about earlier, that under the clear articulation prong, it doesn't matter whether the board acted properly as a substantive or procedural matter under the state law, at least unless there's a situation where someone would say it's clearly ultra-virus. And here, I don't think even the FTC was prepared to try to make that argument, because it's not at all clear that what the board was doing was ultra-virus at all. The focus was on the cease and desist letter issue, but everyone agreed that the board could send letters to non-dentists saying it is the board's position that you are engaged in the practice of dentistry, which is a crime, and if you do not cease and desist, we will initiate legal proceedings to stop. And so the question is really, if that's permissible, is the mere phrasing of the letter that the board did send somehow make it unlawful under state law? That's a pretty narrow and technical state law issue that is a completely open question as far as I'm aware. And so I don't think it would come close to being such an egregious violation of state law as to take you outside of clear articulation. And so I think that's part of the reason why the FTC didn't try to go after it as clear articulation. Rather, they used it for rhetorical force of saying, see, look, this is the risk that you have when you have market participants. They might violate state law.
What is the motivation behind the FTC attack on the state action doctrine? The questioner goes on to ask, what consumer harm can they demonstrate? Rather, it seems to focus on a market preference, not a consumer preference.
So look, I assume their concern is the FTC is just overriding focuses on competition being good for consumers, and they think that even when market participants say, we're doing this for the benefit of consumers, right? So there are a slew of antitrust cases where individual businesses try to justify, anti-competitive agreements by saying this will actually improve public health or safety. And the court has repeatedly said, no, that is just a direct attack on the antitrust laws, which say competition is the goal, and consumers can decide whether they want the benefits of increased safety for increased prices. And so I think what the FTC's position is anytime the state is invoking the state action immunity, there's a risk that even if it's good for public health, it's bad for prices and for consumers, and they generally think that competition is the right way to handle all of this. So it's just a general dislike of anything that harms competition and a general distrust of, I think, state sovereignty. As being, obviously you don't trust private businesses to do things for the public health if it's anti-competitive, and I guess the FTC just doesn't think any differently about states.
Does antitrust law have an exhaustion of administrative remedies requirement?
I do not know the answer to that question. I just don't know. I sort of doubt it does. It's sort of a novel question in the sense that most of the time antitrust law isn't against private parties, so there's nothing to exhaust, precisely because when you're suing state officials, they typically have state action immunity. But I think in a case where a state official didn't have immunity, I doubt that there is a requirement to sort of exhaust challenges to the state first. And I guess that's probably confirmed by the various cases where state agencies have been found to not have immunity and been liable. I don't think anyone actually looked to see whether the private plaintiffs had sort of exhausted state remedy. So while I'm not 100% sure, my initial inclination is that there probably isn't.
Okay, I'll ask two more questions as we're now getting towards the end of the time for the webinar. What, if any, liability do you see regarding past cease and desist actions by the boards? Any retroactive application?
So for past cease and desist letters, I should probably not speak about that one since it's talking directly about the potential liability of my client. I'll let that one pass.
Okay. Do you think that board rules governing advertising and solicitation might be FTC's task after this decision?
So I'm not sure, actually. I don't know enough about what the FTC is most concerned about substantively to know what they're going to focus on.
Well,
sorry to not answer your two final questions.
That's all right. That was an incredible long list of questions that you answered there. Thank you very much, Hashim, for your time and your insights on this complicated issue. It seems like states have a lot to think about and possibly a lot to do as a result of this decision. And I'd like to thank the participants also for attending today. And keep an eye on the State and Local Legal Center's website for future events. Have a great afternoon, everyone.